Next case is BURZEE versus Park Avenue Insurance.
Your Honor, I'm James BURZEE, and I represent the appellant in this case, who is Jane Marie BURZEE. This appeal concerns a non-solicitation agreement, where Ms. BURZEE was the employee and Park Avenue was the former employer. And the former employer alleged that Ms. BURZEE had breached this non-solicitation agreement. Now, this all stems from a summary judgment motion, and in the affidavits that were presented during those motions, all these prior clients that decided to change their business over to Ms. BURZEE's new employer, they actually solicited Ms. BURZEE. She never went out after them. She never tried to solicit their business. In fact, when she got a new job about a month after she was terminated from her previous employer, the new employer told her that she was not to solicit any prior client or any clients from the prior employer. And he said if they decided to transfer their business over to this new employer, Ms. BURZEE would receive no commissions for that, and that those accounts would be house accounts and would be serviced by whoever was available at the time. So,
but the affidavits and the eventual conclusion of the trial judge is that Ms. BURZEE did solicit Saxon Clark and the construction company, Contemporary Construction, and then and also had some connection with I guess a couple of the other ones. I don't remember their names at this point. I mean, the affidavits quite clearly say that.
The affidavits concern Ms. BURZEE. She served about 40-some clients when she left. And about 5 of those clients actually sought her out. Now, the trial judge found that that Contemporary Construction, she solicited that, but there was nothing ever in the record that showed that she solicited from Contemporary Construction. So I don't know where he got that. I brought that up to him, but he just glossed over it. There was another client that he said that she supposedly solicited, which was, I forget the name right now. But this client was actually a client of both insurance agencies already. So I don't see how there could be a solicitation if the client is already a client of both employers.
Well, I mean, Gina Radcliffe from Saxon Clark said on numerous occasions Ms. BURZEE called and communicated with her directly to solicit the services for her new company.
Yeah, Ms. BURZEE said she was giving quotes on the life insurance part. She wasn't giving quotes on health insurance, which was the part that was being serviced by the Park Avenue.
I think, frankly, the most interesting part of this case involves the liquidated damages that were awarded. Would you address that, please?
The damages that were awarded?
Liquidated damages.
Yes, sir. In the non-solicitation agreement, there was a clause which stated what the liquidated damages would be in case there was a breach of the agreement. And the liquidated damages said that the gross amount received from every client that Ms. BURZEE had serviced for the previous 2 years previous to her termination, that gross revenue, not taking into any consideration the fact that part of that revenue would have went to the employee as a commission. It said that the entire amount of gross revenues from clients for the 2 years previous, plus $10,000 was liquidated damage. And we went in and showed that there were only 2 clients that the lower court found that Ms. BURZEE had solicited. Only 2 of those clients actually transferred their business over to Ms. BURZEE's new employer. And if we take a look at just the 2-year period, I mean, that's the only period that's affected by the solicitation agreement. In other words, she could not solicit for that 2-year period. if we look at the revenues from those two clients, and we minus the 30% commission that would have went to the employee, then the actual damages come out to some $20,000. And you have to realize that in this situation where you're dealing with an insurance agency and a past employee and business clients, these business clients, they had no contract with these agencies. In other words, their contract was established with the insurance companies, and the agencies merely service them. So that these business clients, they can move their business anytime they feel like it for any reason because there's no contract. As a matter of fact, the larger client, in fact, the bulk of the revenues that went from the one client to Ms. BURZEE's new employer, they actually changed agencies right after that 2-year period was up. So just to give you an indication that they can change anytime they want. So it's difficult to establish what the damage is. Now, I had cited some cases where the Supreme Court had held that injunctions were the proper remedies for non-solicitation agreements. But the case that I really came back to was the Coleman versus VR Chamber, which was a 50 CA case, 2000. That's 766 Southern 2nd, 27. In that case, the court found that the liquidated damage clause was a penalty, where the damages exceeded 200% of 1 year's gross revenue. And in Ms. BURZEE's case, the damage provision there represented about 850% of what the actual damages turned out to be.
Well, but the key, isn't it, Mr. BURZEE, that is whether you can determine at the time that the contract is set what the damages will be.
Correct.
Right.
Correct. But if there's a liquidation clause at the time of the contract, and if after there is a breach, it's reasonable to determine what the actual damages could be. And if they are grossly, a gross difference between the two, then it's the actual damages that the court should lean to.
Did the employer have the option of either seeking liquidated damages or actual damages under the contract?
I'm not positive. I think it was just liquidated damages. The one other part I wanted to cover was the civil contempt order. Is that?
Go right ahead.
At the point of summary judgment for liability, the trial court issued an injunction against Ms. BURZEE stating that Ms. BURZEE was restrained from any further violation of the covenant not to compete. Actually not laying out or stating any specific or precise dates involved. It sort of refers you back to the contract, the non-solicitation agreement, where in the non-solicitation agreement, they said that Ms. BURZEE could not solicit for a period of 2 years after leaving the employer company. And Ms. BURZEE left the employer on October 4th, 2002. That's when she worked. Ms. BURZEE reported to work on October 4th of 2002, and she was told that she was terminated from her job without giving any reason, no indications. And they had packed up some things in a box, and she left work. That was October 4th. But they also gave her a 2-week severance pay, which the court sort of felt that the 2-week severance pay somehow extended Ms. BURZEE's employment to October 18th, 2002. Now, on October 18th of 2004, Ms. BURZEE handed a secretary a form letter to send out to what happened to be a client of the previous employer. The secretary went ahead and mailed it out on that day. October 18th. What we're contending is that Ms. BURZEE never had any intent to violate that order. I don't know why she'd wait till the very last day. If October 18th was a valid date, I believe that the October 18th, the October 4th date is actually the 2-year period, because she was terminated on October 4th. But the order never specifically stated a specific date. Now, the court found her technically in violation and fined her $100. But this court order was not clear and precise. And I've listed a number of 50 CA cases which says when that order is not precise, that it should not be followed. And there's no behavior to indicate that she clearly intended to violate the order. So in that case, we're asking that the contempt order.
And the attorney's fee issue that grew out of the contempt order is not before us at the present time. Is that correct?
The court did award attorney fees of some in excess of $10,000.
That's not before us.
Yes, it is.
Did you raise that as an issue somewhere?
Yes, I said along with the attorney. Because I made an argument in my brief that even if the lower court decision was upheld, saying it was a technical brief, technical meaning insufficient, I said the attorney fees should not have been awarded.
Well, when were the attorney's fees awarded vis-a-vis your notice of appeal?
Excuse me?
When were the attorney's fees awarded as compared to your notice of appeal in this case?
Before or after?
Before. Yeah. There was 3 different attorney fees that were awarded. One was for the liability. In the court, it was a year or so later before the court did the damages part of the summary judgment. And then in between was the contempt.
All right. Would you like to save the remainder of your time for rebuttal?
Yes, sir.
Thank you. Ms. Moses?
May it please the court, Jamie Blighty Moses from Fisher Rushmer in Orlando on behalf of Park Avenue Insurance Company. With respect to the last issue that was just raised, the attorney fee award on the contempt finding was post notice of appeal, and it has not subsequently been appealed. It is our contention in our brief that the attorney fee award related to the contempt proceeding is not before the court and is not an issue that's subject to be considered. Mr. BURZEE does bring...
Why is the liquidated damage provision not penal in nature?
Okay. In order to find a liquidated damage provision valid, there are 2 prongs. One is you can't ascertain the damages at the time of the contract, and I believe that that's been conceded by opposing counsel. The second issue is whether it's so excessive as to constitute a penalty and therefore be invalid. In order to...
Well, let's say that she violated the non-compete covenant for 1 second. She violated the non-compete covenant. 1 second involving maybe 1 customer that she made $100 on. Isn't the liquidated damages the same under that circumstance as if she violated it for the whole 2-year period?
Yes, the judge would have the ability to determine that the liquidated damage provision was triggered and therefore award the damages. The problem here...
This liquidated damage provision there's no relationship between the gravity of the breach and the sum of money that the employer is entitled to upon breach, right?
Correct. But many liquidated damage
Why isn't that penal?
It's not penal. Well, there are 2 issues here.
Why isn't that excessive?
Okay, 2 issues here, and I'm trying to get to it.
All right.
You have to prove the excessiveness, and the burden is upon the employee that violated the non-compete to prove that the liquidated damages provision is excessive. What was offered in this case was Hugh Cotton's profits on the 2 clients that were successfully taken, no issue whatsoever with respect to what Park Avenue suffered. And the testimony that we put on with respect to our clients is we've been in business 25 years. The majority of our clients have been with us for over 20 years. The minimum amount that most of our clients have been with us is 7. They never offer any testimony to show what we've lost as a result of those two clients not being with us for 2, 5, 10, 15, 20 years. That's the measure of damages. It's not, because also Hugh Cotton may have a different breakdown with the people it services and its clients as compared to Park Avenue. We may have gotten a greater percentage of a commission versus Hugh Cotton. To put on what Hugh Cotton makes in a 2-year period versus what we've lost potentially for 7 to 10 to 20, those are apples and oranges. So it is our contention here that the court couldn't have just declared it a penalty. They had to argue it was a penalty, show it was excessive as compared to the actual damages. They never met their burden, and the case law is clear that it's their burden to show it's an excessive amount as compared to the actual damages. They never did that.
Is it clear, Ms. Moses, that you're entitled to recover damages for beyond the 2-year period?
For beyond the 2 years?
Right. There's a 2-year non-compete.
We weren't seeking damages beyond the 2 years.
Well, you just said 5, 10.
That's how you show whether it's excessive. I'm not saying we could have gotten 15 years of commissions that we lost or 20 years. What I'm saying,
You could have only gotten 2 years
we
of
could have
commission.
only gotten 2, which is all that was awarded. But to establish the excessiveness, it's whether the penalty is excessive as compared to our actual damages. And our actual damages, to put on the proof of that, could have been 5, 10, 15, 20 years.
I'm not understanding your point. If all you could recover as damages is for the 2 years, then how can you claim a loss of greater than the 2 years?
We are not seeking to recover a loss of greater than 2 years.
Well, I mean, that's how we judge the penalty, is what you actually would have been able to recover if the damages were to be proved versus what the liquidated damage provision is. If you could only recover for 2 years, then why do we care what you lost for 5, 10, or 20?
Okay, then I misunderstood you, and I apologize. I think there are two different standards. When you're analyzing a liquidated damage provision, and it's as compared to actual damages, if we had just sued her for what she wrongfully took from us, okay, and the damage it caused us, we could have put on evidence of 5, 10, 15, 20 years. It's the liquidated damage provision that she voluntarily entered into in her contract when she started her employment with us that caps us at 2 years. So again, I think we're talking differently. If we just...
So we were misunderstanding one another. So it's your position that if she, by proving that she stole client X, you could then put on evidence, or I don't know what evidence you put on, but you could contend that but for her violation of the non-compete agreement, this person would have remained your client for 50 years.
Possibly. Yeah, I don't think we'd go as far as 50 because we haven't had a client that long.
Well, you could.
But we could demonstrate...
I guess it's bounded only by the rule against perpetuities, maybe. You know, it's totally speculative. I'm surprised that would be the measure of damage.
That would be the measure.
I'm surprised that you could recover for more than just the 2 years. Because she was free to compete and steal your client 2 years from now.
But the key, and the reason why I think there are liquidated damages provisions and non-competes is also highlighted by their brief wherein they argue, I think wrong, but they argue, no, they went to Hugh Cotton because of Miss BURZEE. They loved Miss BURZEE so much. You know, that's why they went there. But that's why
she was entitled to go.
Yes, but my point is, if she can't do anything for 2 years,
and she just can't solicit for 2 years.
Well, actually, ours is pretty broad. It says call upon, communicate with, or endeavor by any means to sell or solicit.
Right.
And the judge felt that, and that's why where you were talking about Gina Ratcliffe and some of the meetings that she insisted upon, that's why the judge found a violation, because he found even if there had been an initial contact by that client to Miss BURZEE, once she tried to service them, attend meetings, explaining policies, explaining benefits, she's communicating within the 2-year period, and she shouldn't be. It was the judge's interpretation of the contract, which was a question of law, and he was allowed to do, that it was broader
We
than...
can review de novo.
Yes, ma'am, and I appreciate that. But that de novo review also brings in the Matheson hardware testimony based on the contempt, where Ms. BURZEE testifies, Volume 5, page 835, I was fired on the 4th, 2-week severance. October 18th was the day I knew I needed to wait until I can do something. I prepared the paperwork, gave it to the receptionist, told her not to mail it till the next day. Ms. BURZEE has admitted in her testimony that she thought the 18th was the golden date. She knew she wasn't supposed to do anything until the 18th. It's just unfortunate that the receptionist mailed out the letter the day before. Yes, the court found a technical violation because it happened to be the last day. But if we were to allow employees to decide the last day's okay, the last week's okay, maybe the last month's okay, I don't think we want to go there. If there's a 2-year period, there's a 2-year period, and if you breach at any time within the 2-year period, you're in violation.
If she had solicited a client unsuccessfully, albeit in violation of the non-compete covenant, would you be entitled to liquidated damages measured by 2 years gross earnings plus $10,000?
That is our position, that by violating
That's
it...
pretty harsh. And I mean, you know, the second problem that I have with this liquidated damage provision, I guess I got 3. One is that there's no relationship between the gravity of the wrong and the amount of damages. 2 is that it clearly includes gross earnings rather than lost profits. And 3 is you get another $10,000 on top of that for what I don't know other than the penalty.
Okay.
Why don't you address all that?
I'll try to do it backwards. The $10,000 on top of the gross, we happen to have Ms. BURZEE a very successful agent. If that had been another agent who had done this and had not been so successful, the $10,000 may not have seemed as much on top of the 151, I believe was the number. That is the way it's written. It's not... I'm struggling with, the court's struggling with, that there has to be a relationship to the gravity of the offense.
If she has stayed there for the 2, if she had worked there for the 2 years, that your client would not have earned the entire commissions. They would have had to give her split of it.
Yes, but the problem here is we no longer have the client. Although some clients are not with Hugh Cotton anymore, we've lost clients because of her. And again, it's 5 years, 7 years, 10 years, 20. We've lost some big accounts because of Ms. BURZEE.
Right.
But there were only 2 that she solicited. I mean, the fact that they just went away when she left isn't her fault.
Well, no, and I think the evidence is different than that. There are 2 that came out.
Well, there's certainly some evidence that some of them just went away when she left.
They went away after discussing with her, and she gave them 3 different names of other people to work with, Hugh Cotton being one of them. There's also testimony that she was speaking with the clients about what a horrible place Park Avenue was, and that Brad Thompson was
She had a right to do that.
while there.
She had a right to do it while she was there. She had a right to do it when she left.
But the point is that her actions resulted in suddenly us losing clients we hadn't lost up until she left. Our damages are just more than the commissions we would have gotten in that little 2-year window. We potentially could have had these clients, again, 5, 10, 7, 20 years. We'll never know, because as soon as she left and started talking about us and soliciting them, we lost them.
Is this a liquidated damages clause? I know that's what it's called, but is it a liquidated damages clause?
Versus?
Well, my definition of liquidated damages is when 2 parties get together and they agree to a specific amount of damages. This looks more like an agreement this looks like more like an agreement to a measure of damages that needs to be calculated at some point in time upon breach.
I do believe it's a
So you
liquid.
pick $100,000. That's a liquidated damage amount. This looks like a formula.
But the reason why there has to be a formula is because it is difficult to ascertain what the damages would have been at the time of contract. And that's been...
I'm with you on that. And you know what? To me, an enforceable formula would have been or an enforceable liquidated damage provision for a non-compete covenant would be, $100 a day or $1,000 a day for every day that the employee breaches. Because then, there's a relationship between it has to be an attempt at, there has to be an attempt to approximate damages. I mean, it clearly can't be, penal in nature from the outset. And when you have a provision such as this that doesn't have, where there's no relationship between the gravity of the breach or the length of the breach and the amount of damages, it just seems to me that's penal in nature at the beginning.
I don't know of cases that say those standards have to be established. I have not found a single case that says it has to be related to the gravity of the breach or the length of the breach. Many non-compete liquidated damages clauses have been upheld that have limited it to, for example, she couldn't compete for 2 years. Our damages are limited to a 2-year period. The Coleman case relied upon by opposing counsel. My understanding of the problem that Judge Floyce and Judge Griffin and Judge Sharp had with that provision, I thought, was that it subjected the calculations to not just running some numbers, but to the CPA making a determination of what the damages were and then advising them later, and that ended up being 200% times gross revenue. We don't have a 200% times gross revenue issue here. What they said is this is what it will be. Now, when we hire Jane Marie BURZEE, we don't know if she's going to service 25 clients and potentially try to take 25 clients when she leaves, if she's going to service 5, if she's going to service 45. That's why at that point in time, we can't say, $1,000, $2,000. That's why it also allows us.
I know. That's why. And you all didn't bind yourself, in my view, to a liquidated damages has to run both ways. And your client really got the best of both worlds. They picked a measure of damages which was fluid in nature, so that if she, if 5 years down the road she was making more money, then presumably the damage amount would be higher because the 2 years preceding her departure would have been higher revenues. So they had a nice fluid number where they're not, if she makes more money, the number's going to go up, plus a $10,000 kicker, plus no account for the fact that your actual measure of damages is lost profits and not lost gross revenues because she's entitled to a commission.
But our lost profits could have been, as we've said, 5, 10, 15, 20 years. It's capped at 2. Secondly, if she's making more money, that means more clients that she's exposed to that she can potentially take from us. So that's the tie-in. If she is servicing more...
Were you entitled to an injunction?
Yes.
Did you get an injunction?
Yes.
Okay.
That's why she was found in contempt, because the court...
You had got the injunction the day after she left her employ. Are you still entitled? And to get an injunction, you've got to show a breach. So she's out there calling your clients the day after she leaves. You get an injunction. Are you still entitled to liquidated damages?
Okay. In this case, yes, because we proved even after the injunction she continued to do what she did.
All right. It's a hypothetical.
In a hypothetical, if we had gotten an injunction the day after and she did nothing else after that,
Right.
Absolutely nothing, we didn't lose a single client,
Right.
I haven't looked at it that way.
Well, I mean, it says you can, right? If she breaches, you're entitled to liquidated damages.
It appears that that's the way it's written.
Why isn't that penal? Why shouldn't we say as a matter of law that that's penal in nature?
Because the liquidated damages provision has to be analyzed at the time it's entered into by the parties. Your hypothetical, number one, creates a situation where we were able to go in the day after she was terminated and get her from not violating it. That hypothetical adds a nuance to the liquidated damages clause that is not there when the two parties sit down and contract and decide what's an appropriate remedy if you are terminated and within the 2-year period you violate it. Is it a penalty then? And I would submit to you it's not. At the time the parties are contracting, they're sitting down and discussing what's the potential, not discussing, forgive me, she had to sign it, so it wasn't like it was discussed or negotiated. But what's the potential damage this employee could do when they leave. If she's a very successful agent in our employ, meaning she's making some good numbers, the damage is even greater because she has more contact with more clients. If she had serviced one client, okay, and the commissions for the 2 years were $1,000, we would have recovered $11,000. Is that excessive and unconscionable, considering the fact that that one client may have stayed with us 5, 10, 15 more years? I think you have to analyze, and I think the case law says, the liquidated damage provision at the time the parties entered into it, not an after-the-fact analysis of what she did or didn't do. Although, in my opinion, the facts of this case demonstrate that she was working the whole 2 years trying to get this business one way or another. If you look at all the affidavits, they're different. November of 02, January of 04, March of 04, October of 04, she's writing this letter. I mean, she's all over the place trying to get this business one way or another, whether it's an initial direct contact, writing a letter, or calling Gina Ratcliffe at Saxon Clark, or it's servicing CapTech's meetings with the employees or Contemporary Construction and going to the employee meetings and explaining their group health insurance benefits. She is working along the whole way, calling upon, communicating with, or endeavoring to get this business. So the after-effect analysis in this case, I think, would actually support the liquidated damages provision. She's breaching it the whole 2 years. Maybe $200 a day would have been better for us. I don't know. But she, you can't put that type of...
$200 a day would have been a more palatable, in my view, way. It would have been a more accurate way to attempt to measure, actual damages, or have some correlation between actual damages and the number that was agreed upon.
But I disagree.
I mean, at the beginning, when this contract was made, the parties could contemplate that there might be a minuscule breach, as well as a breach that may, be pervasive over the entire 2-year period. But, they made no attempt, there was no attempt by the employer in drafting this contract to do anything other than extract some penal sum from an employee.
I have 4 seconds. May I answer?
Sure. Keep going. I have a question for you, too.
Okay. Respectfully, I disagree. I don't know how you could put a dollar limit on this. This isn't like a building that's not being finished and people are saying, look, $250 a day until it gets finished. Because once it's finished, the damage is stopped. You finish my building, I get to occupy it, I'm done. And that was the Osceola versus Bumblebee construction case where they said I think $2,500 a day was not an unreasonable, maybe it was $250 a day, not an unreasonable penalty, and because of the tourism threat, that was an issue. What we have here is clients that were once ours, established clients that are no more. Our damage doesn't stop. We are damaged today as we stand here today because we don't have Saxon Clark, Langston Hess, many of the people she dealt with as our clients.
Let me ask you something.
Yes, sir.
I want to make sure I'm interpreting this correctly. Do I understand that in the event of a breach by the employee, then the entire commissions earned by any of the clients that she serviced during the 2-year period are one of the factors in the final liquidated damages number? In other words, if she only takes one customer with her, the liquidated damages are still 2 years' worth of the commissions earned on all of the people she serviced.
Yes, that's the way it's written, and that's the way
it's been enforced.
Judge Brentowitz enforced it. We presented as evidence the 2-year stream of every client she serviced.
But why does that have any relationship at all to damages suffered? I don't quite understand.
Okay, again, I feel like I'm...
Back from the outside. I understand that.
No, I feel like I'm trying to prove something that should have been proved down below. To be candid, no effort was made whatsoever by Ms. BURZEE to show what our actual damages were and then to prove it was excessive.
I think that's actually your strongest point.
Excuse me?
I said I think that's actually your strongest point.
Right,
We're
and
all struggling with this liquidated
I'm
damage.
trying to make it, the burden was not met down below to prove that ours are excessive.
Well, how would they prove that? I mean, they can't prove what you would have received in commissions because the client isn't with you anymore. The only way they can show or approximate a showing is to show what Hugh Cotton received in commissions, which is what they did.
Actually, and I disagree with that, and I'm way over my time. Hugh Cotton has a different relationship with these people. Their commission.
Well, maybe they do, but the fact of the matter is they're not with you anymore.
But you-
So there's no way to show what they would have paid you in commission.
Actually, I mean, all they had to do was subpoena our records, our past history with these clients, and argue. I mean, Mr. BURZEE could have stood up and argued, look, that client was going to leave tomorrow, and we may have put on testimony and said, no, that client's been with us for 15 years and would be there 5 more. There's stuff they could have, there's information they could have tried to obtain from us, which they didn't, presented it to the judge, and argued to the judge the argument you three are making right now, but it wasn't made. They could have argued this is excessive because this is their actual damages or our best guesstimation of what their actual damages would have been. And I will tell you, not even was it put on what we lost during the 2 years of the same numbers they put on for Hugh Cotton. There wasn't even an effort to put those on for us. What would it have been with our numbers and taking out Jan Marie BURZEE's commission? That wasn't even done. The effort here was, this is what Hugh Cotton has made, those are your damages. Hugh Cotton's profits are not our damages and wouldn't have been our profits either. Absolutely no effort was made to do this analysis that this court is doing right now, and I don't think appellants should get the benefit of that.
Well, and I've got one more question for you, even though you're over your time. As I read this, what we're talking about is the entire commissions that the company would have earned on the accounts that she serviced during the 24 months prior to the month in which she left the company. So what that basically assumes is that she walks out the door with everybody.
Yes.
Okay, that's the worst case scenario.
Plus 10 grand.
Plus 10 grand, plus 30%. Isn't that what her commission would have been?
I need to be honest with you, I didn't think the plus was done on top of that, but.
Well, it says $10,000 plus all of these commissions, and it's the commissions that the company would earn, not the commissions, not their net commission.
I see where you're going.
So what we're talking about here is somewhere in the range of $55,000, aren't we?
It was $151,000.
$151,000, and if the commission is 30%, then that's.
I see what you're saying.
So, I mean, that's worst case scenario. She walks out, she takes everybody. You've got a liquidated damages clause that basically hits her with some $55,000 more than,
Plus 10.
well, 45 plus 10, you know, math. If I'd have been good at math, I wouldn't be here. But you know, that's the trouble I have. I mean, I have some sympathy with the notion that you could say, okay, let's assume on the day you leave, you take everybody. But even this is overreaching for that reason.
And I will tell you that argument wasn't made below. They stipulated to the amount of liquidated damages.
I know they did that. I mean, you can't help but stipulate to the amount of liquidated damages. I remember seeing that in your brief. But they do contend that this is excessive. Anyway,
They contend it's excessive, though, based upon the wrong factors. None of this analysis went on down below. It was Hugh Cotton made $29,000. You want $151,000. It's too much. That was their analysis. That's not the standard. It's what would our actual damages been, and no effort was made whatsoever.
Actually,
to prove
not
it.
what your actual damages would have been.
Say it again?
It's not actually what your actual damages would have been, because your actual damages assume that they take all of the clients, that she takes all of the customers with her.
But the standard to judge it by is what our damages were.
Oh, I understand.
And no effort was made to prove what they would have been. Again, she stopped working there 2002. It is 2006 right now. We still don't have those clients that are gone because of Jan Marie BURZEE. It's an ongoing issue. again, why a liquidated damage provision is appropriate, because it couldn't have been ascertained at the time of the contract, but also why it would have been difficult to prove that it was excessive, because they're still ongoing. We have been damaged by her taking our clients.
Okay, we're now 7.5 minutes over, so thank you very much, and we'll ask the appellant. You have 7.5 minutes, but I'll tell you we'd be lenient if you wanted more.
I just had just a couple of points I wanted to make with rebut what she was saying. And that is, she keeps mentioning about what damages they could have had 5, 10, 15 years down the road. It makes no sense, because like I mentioned, these business clients have no contracts with these insurance agencies. I mean, maybe there is a damage 5 or 10 years down the road, but it could be one day down the road, because they can leave anytime they want. And when we talk about excessive to who? Maybe $160,000 isn't excessive to the insurance agency, but $160,000 to an insurance agent who's making around $40,000 a year gross, that's not excessive?
Well,
That agent would be hard pressed to even make the interest payments on the judgment.
The one issue that I'm still troubled with is whether or not you met your burden of demonstrating that the liquidated damages clause was actually a penalty clause below. Would you like to address this? And Ms. Moses says you never raised any of the arguments that we are discussing here today.
Okay, well, in the lower court, I did mention that I thought it was a penalty because it was excessive. And we tried to put together what the actual damages were, and that's the figure. We came out with around $20,000. And that's the actual...
That's the actual damages that Hugh Cotton would have suffered if they had been the employer.
Yes.
How does that relate to what the appellee's damages are?
Well, we're just looking for what's happening over the 2-year period that the non-solicitation agreement is in effect. I mean, after the 2-year period, she's got every right to go out and solicit every single client that Park Avenue has.
Well, her argument is that there is a fee structure at her client's shop that is different from the fee structure at Hugh Cotton's shop. I don't know if there was any evidence offered of that. Maybe there was. I don't remember now. But because her fee structure at her shop is different from Hugh Cotton's fee structure, showing what Hugh Cotton earned as a result of Ms. BURZEE's actions doesn't prove what they lost as a result of Ms. BURZEE's actions. And by failing to prove what they lost, you have failed to establish the one half of the second prong of the test, which is why this is excessive. You can't prove it's excessive if you can't prove if you didn't prove what they lost. That's her argument.
Okay. Well, when we went and figuring out the $20,000 of loss commission to Hugh Cotton, the agencies are very similar on percentages. I mean, what they make from the insurance companies are similar.
Is there evidence of that in the record?
No.
Oh.
Anything else?
All right,
Thank you very much.
Thank you all for your arguments.